Yes, Mr. Ackland.
May it please your lordships, we were looking yesterday afternoon at the end of the day at 100% replacement in the context of Route 3.
Yes.
And in particular, example 7, which is one of the disclosures in UPenn, that my learned friend relies upon as general teaching that 100% replacement is best. And he submitted yesterday that this general teaching is applicable to all nucleosides. I don't accept that, in that there are only 3 nucleosides which are actually tested in example 7, M6A, M5C, and pseudouridine. But in any event, there is, in my submission, a much more fundamental problem with my learned friend's case. And that is that there is no teaching in UPenn that 100% replacement is best for all nucleosides in the context of translation. That is to say, when they are incorporated into messenger RNA, which, as your lordships know, is the target as far as this case is concerned. My submission is that when UPenn is read as a whole, as it must be, it teaches that 100% replacement is most certainly not the best when it comes to translation. And to that end, could I ask your lordships to take the supplemental bundle and turn to tab 7. Apologies, this is another document that is in landscape. Now, this is an overview prepared by Professor Rosenecker of each experiment reported in UPenn, with which Dr. Enright...
For some reason it won't turn.
I'm sorry.
Okay.
With which Dr. Enright agreed, the summary. And so you can see on the left-hand column the list of examples. And for each example, the third column identifies the property under investigation, be that immunogenicity, translation, or RNA stability. And the last column shows the modified nucleoside or nucleosides that were under testing. Now, your lordships can see from the third column that the immunogenicity experiments, with one exception, which is the last one, the last figure, run up to example 9. And your lordships can see example 7 is one of those. The translation experiments begin at example 10. Example 10 is translation in vitro. You can see that from the colour coding in the fourth column. In vitro meaning in a test tube. Example 11 is translation in 2 different cell types, so cells cultured in a petri dish. And example 12 onwards, if your lordships look at the particular modified nucleosides which were being investigated, pseudouridine is the only one that features in the experiments from 12 onwards, including the only experiments which were conducted in animals. Now, could I show you, it's in the same tab, the same bundle rather, what Professor Rosenecker said about examples 10 and 11. So those first 2 translation experiments in that table. It's in the supplementary bundle, tab 23. And picking it up at the foot of page 322 of the bundle.
Right, this is part of his written...
This is part of his first expert report.
Right. And
at paragraph 200, at the bottom of the page, he describes example 10. He used 3 different cell-free systems to translate unmodified and modified messenger RNA encoding firefly luciferase. 3 modified nucleosides were assessed. It's M5C, M6A, and pseudouridine. So the same modifications that were tested in example 7. He then, in the next paragraph, reproduces figure 9 from UPenn, and on the x-axis, he explains that luck C refers to unmodified RNA, and then we have M5C modified, M6A modified, and luck Y is pseudouridine modified. And he says in 202, paragraph 225, UPenn says that pseudouridine M5 modification increases mRNA translation efficiency. Skilled person would not agree. The data in figure 9 show that psi modification increased the efficiency of translation, whereas M5 modification reduced translation. Then he gives an account of example 11, and as we saw in his annex, example 11 is two different cell types. The first is shown in figure 10a, and it's the same legend for the different constructs. Unmodified, that's Ranilla C, Ranilla M5C, M6A, Ranilla Y is pseudouridine, and M5U. And then the second figure that he's reproduced there, figure 10b, are the results of translation experiments in a different cell type, murine DCs. And could I ask your lordships just to read to yourselves paragraph 204.
Yes.
My submission, your lordships, is very simple, which is reading the whole of UPenn rather than just example 7. There is a clear teaching that the effect of 100% replacement on translation varies between different nucleosides. And in the case of M6A, 100% replacement is actually worse than 5% replacement. And in my submission, in the light of those translation results for M5C, M5U, M6A, and pseudouridine, UPenn does not disclose a preference for 100% replacement of messenger RNA. Now, my learned friend characterized that submission, it's a submission that is made in our skeleton argument, as desperate stuff. He said it wasn't foreshadowed anywhere in the evidence at trial, and I've shown you the evidence that founds that submission in Professor Rosenecker's evidence. So, in my respectful submission, he's wrong about that. He says it wasn't run before the judge, and he's wrong about that, but only in part. Can I hand your lordships a clip of two documents?
Thank you. Thank you.
Now, the first of those, which I'm going to address you on, is this document, the chart.
Yes.
And then I'll address you on the clip of correspondence in just a moment. Can I ask your lordships, so we get the chronology right, to take my skeleton argument and turn to...
Have we finished with the supplementary mark?
Yes, you have. Could I ask your lordships to take my skeleton and turn to paragraph 23. Page 315 of the bundle. And in paragraph 23, we've given a brief account of the genesis of route 3. And as we've explained there, route 3 was not included anywhere in my learned friend's opening skeleton argument. for the trial, but it did emerge in the course of his opening speech. And as articulated in my learned friend's opening speech, there was no reference to example 7, nor any suggestion that the general teaching in UPenn was to 100% replacement as being the best or preferred. And that case was maintained in the way that I've articulated it in my learned friend's closing submissions. Now, upon exchange of closing submissions, the judge asked for a single set of submissions from both sides on the law, and he asked for novelty submissions to be reduced into chart form. Now, those charts were exchanged in the usual way, and it was only at that point that example 7 emerged in my learned friend's case. So what I'm showing you here in this chart, which is the first document I asked your lordships to look at, is Moderna's submissions to the judge in chart form prior to sight of my learned friend's case as set out in the chart that we've seen in the supplementary bundle.
So this was your document?
That's right.
In response to the judge's request at the end to provide him chart form?
Correct.
Can I just check what you're doing at the moment?
Yeah.
This is a variant on the theme of if it's an implied term, it must have been obvious, and if somebody can't specify an implied term in a contract from the start, it's probably because it isn't a good implied term. This is a forensic exercise at the moment you're
Yes.
engaged on.
Well, actually, the exercise that paragraph 23 and 24 engages is a slightly different one. It's not the exercise I'm engaged with now. The 23 and 24.
23 and 24 said, hey, look, they didn't say this at the start, so how can it possibly be clear and unmistakable? They've only tumbled to this
That's right.
at some point belatedly, so it can't be any good.
Well, you can't rule it out, but it
Just depends how
interesting.
blunt you're prepared to be in advocacy, but that's the gist of what
That's
23
the
and
gist
24
of the
say.
written submissions in my skeleton argument. The
Okay.
submissions that I'm making in the moment are simply going to a different proposition, which is my learned friend says that this argument about percentage modification and its effect on translation was never deployed before the judge.
Ah, okay.
And
So-
I'm simply saying that it was deployed, at least in part, and that's what I'm showing you now. So I've simply shown you the chronology,
Right.
in order that your lordships, I hope, understand what this document, where it sits in the chronology of events.
Fine. Okay.
And so, if your lordships look at the first page, what's described as the first route is route 3, and you'll see that there is no reference there, because it wasn't part of the case as we understood it, that example 7 had any relevance. And that's why you'll see in the first row, starting with paragraph 4, paragraph 6, 56, 51, 74. That is the way in which it had been articulated in opening and in the closing submission. And I can take it quite quickly, because if your lordships please turn to paragraph 13 of this document, this is where we identified in brief form our submissions in relation to 100% modification. Paragraph 13 is self-explanatory, I think, a long list of potential percentages, no disclosure here of any preference. Paragraph 14, nor does the rest of the document teach unambiguously that 100% modification is what should be adopted. Indeed, the disclosure of paragraph 214 to 218 points firmly away from that. Interestingly, or rather I should say, as it happens, we were alighting upon the textual disclosure of example 7. But of more relevance for current purposes is what we said in paragraph 15, where we said, furthermore, figure 10b shows that mRNA containing 5% M6A is more efficiently translated than mRNA containing 100% M6A. Now, it's fair to say that in my oral closings, and likewise in my learned friend's oral closings, when it came to pointers to 100% replacement, both of us largely adopted what we had said in writing. As far as we were concerned, what's set out in this document, and as far as my learned friend is concerned, the bullet points which he identified in his chart. So that is why I say my learned friend is right, in part, when he says that the argument wasn't deployed in front of the judge, because certainly I didn't at any point refer to figures 10A and 10B, or figure 9, which are the ones that I've just taken your lordships to. He is also absolutely right that there is no reference to these materials at all in my respondent's notice. However, that was the subject of correspondence between the parties 6 weeks ago, and that is then the second clip which I have handed out. The lordships should, I hope, have 2 items of correspondence. The first from my instructing solicitors Freshfields, and in the first opening paragraphs of that letter, we enclose by service Moderna's skeleton argument in response to the appeal. Second paragraph, your client's skeleton contains a number of new arguments that were not foreshadowed in the grounds of appeal, including but not limited to submissions regarding the issue of 100% replacement under Route 3. Moderna has nevertheless addressed the new arguments in its responsive skeleton. It will not insist on the grounds of appeal being amended, provided that your clients confirm that Moderna's counter-arguments do not necessitate any amendments to the respondent's notice. And then, if the lordships then turn to the response to that letter, 10th of June from Taylor Wessing, second paragraph, we don't accept your contention that the appellant skeleton contains a number of new arguments, not foreshadowed. In our view, the appellant's submissions are properly within the scope already outlined. We do, however, agree with your client's skeleton includes points which are not presently the subject of the respondent's notice. Notwithstanding above, we consider it's not fruitful to engage in a wider dispute over this side issue. Therefore, whilst reserving the appellant's position, there is no basis for your client to insist on any amendment to their grounds of appeal. We accept your suggestion and prepare to confirm we do not consider it necessary to seek amendments to your client's respondent's notice. Now, of course, respondent's notice or otherwise is not simply a matter for the parties. And notwithstanding Pfizer BioNTech's position, if your lordships consider that it is necessary to amend my respondent's notice, then I would ask permission to make the amendments. And the amendments which I would seek to make track my submissions in my skeleton at paragraph 68 to 69. Actually, no, it's 67 to 69. Could I ask your lordships just to review those?
Yes.
So I don't know how your lordships will wish to proceed. You may wish to hear from Mr.
Well, you can deal with that in response.
Indeed. Well, subject to that, I can, I think, finish route 3 fairly quickly. My learned friend's submissions yesterday on the residual matters essentially track what he said in his skeleton argument. And rather than simply repeating my responses to that orally and taking the time to do that, can I alert your lordships to paragraph 64 to paragraph 75 of my skeleton. I wasn't proposing to elaborate on those. That's pretty much all that I wish to say. However, just going back to the judgment, there is just one outstanding matter, which is paragraph, the judgment, paragraph 339. And you may recall my submission that in paragraph 339, the judge is adopting the principles which he derived from the European Patent Office and which he set out in paragraph 139 of the judgment. Now, there's no criticism that is made of the judge's account of those principles in paragraph 139. And 339, the judge makes two observations. First of all, he refers to the absence of any pointer to the combination of M1 psi and 100% replacement. That's the first one. And my learned friend submission to you yesterday was that that makes no sense, because UPenn, he says, contains a general teaching that 100% is best. But I've explained, UPenn doesn't contain a general teaching that 100% is best in all circumstances, and in particular, not in the specific context with which we are concerned, namely messenger RNA. And then the second point that the learned judge makes in paragraph 339, he says that the case requires combining something preferred, 100% replacement on this assumption, with something in an unclear and apparently open-ended list, M1 psi. What the judge is alluding to there, and one can see it in paragraph 139, is the cases in the European Patent Office where it has been held that there is added matter in combining a preferred member of one list with another member, with a member of another list for which no preference is given. And we submit that the judge is simply applying that principle here. There is no preference for M1 psi. That is what is identified at 336. It's saying that even if 100% is preferred, that is then a combination between something that is preferred and something that is unpreferred, and also happens to be in an unclear and open-ended list. It's the lack of preference which, in my respectful submission, that is what the judge is alerting the reader to. As my learned friend reiterated yesterday, his case is, as it was below, that Route 3 comprises clear and unmistakable directions to make something falling within the scope of Claim 3. And for those reasons, my lords, I submit that Route 3 doesn't come close to that, and the judge was plainly entitled to reject it. Can I then turn to Route 1? And just to remind you, if I may, Route 1, as it was advanced before the judge, that's in the novelty chart, and in Pfizer BioNTech's appeal skeleton, is anticipation of Claim 3 because, 1, M1 psi is individually disclosed in paragraph 291. And the correct construction of example 31 is that it teaches the skilled person to make all the RNAs disclosed in example 2. And that therefore includes messenger RNA. May I begin by looking at the judge's findings in relation to Route 1. My submission is going to be that those findings plainly and necessarily defeat Route 1, but can we take them in stages? The judge's findings begin at 321, page 116 of the judgment. And these are findings that are made in the context of Moderna's submissions. And insofar as these findings are challenged, I will deal with those challenges as we go. But the first finding to alert your lordships to is the second subparagraph of 321. The judge refers to the evidence from Dr. Enright and Professor Rosenecker that the example was a suggestion. One could go and try things, potential modification. He says usually evidence from the experts on the meaning of the disclosure will be regarded as inadmissible, questions for the court. But here I think technical understanding is useful and necessary to appreciate the real gist of what's been proposed, but in any event I would reach the same conclusions as the witness. So potential, my lords, potential in the sense of modifications which have the potential to decrease immunogenicity and increase translation. Not a disclosure that such modifications actually exist, as the judge finds in paragraph 377, the list in paragraph 291 is prophetic. The next finding, sub 3, example 31 is open-ended, and the judge says the most concrete textual example is the word, or the words include e.g. in paragraph, at line 10 on page 74, so that comes at the end of, just before the list in 291. Now, my learned friend said yesterday that the judge got distracted and should have been focusing on what example 31 tells the skilled person and not what other things might be included. And was what does example 31 tell the skilled person? It is an invitation to consider other modifications, and those to be considered include, but are not limited to, the modifications listed in 291. And your lordships will recall that this is not a specification that is shy to call out modifications beyond those which are specifically named. We saw that in paragraph 56, any other pseudonym known in the art. Then little Roman 4, total number of things proposed, multiplying the 96 possibilities in 291 by the number of RNAs and methods in example 2 and example 7 was enormous. It would take a very long time. That was a submission. And the judge records that Dr. Enright accepted the skilled person would not think they were being told to do all the possibilities. And again, I think expert input is admissible, although I would have reached the same conclusion myself without it. Can your lordships then turn over the page, please, to page 117. And in paragraph 322, the judge says, in my view, Moderna has much the better of these arguments. There's no anticipation by route 1 or 2. So he's now going to set out his reasons for rejecting the anticipation case. And in 323, he says that example 31, first of all, is extremely tentative. And in my submission, when the judge says extremely tentative, he's simply reflecting his previous finding in paragraph 321.2 that this is a suggestion that one could go and try other modifications. He says it's open-ended, I've dealt with that. He goes on to say in the last sentence of 323, the extent of what it is proposing is woolly, and the reasons for doing it are woolly. As far as extent is concerned, the judge is right. The extent is woolly because example 31 provides no assistance as to which modifications to consider, and it's not even confined to the list of 96. As regard the reasons, my learned friend says, well, the reasons are perfectly clear. To test the immunogenicity and translational efficiency of additional nucleosides. In my submission, that ignores the judge's citation of Dr. Reddy's at the end of paragraph 323. And your lordships will recall that in paragraph 31 of Dr. Reddy's, Lord Justice Jacob referred to individualisation being partly one of degree, but other considerations may come in too. For instance, the specificity of any indicated purpose for making the compounds, a mere woolly indication of the possible use of the prior class may require less specificity, in other words, deprecated. So the reasons for testing additional modifications are woolly in my submission, and in my submission this is what the judge was finding, because example 31 simply teaches the skilled person to look for other, better nucleosides, but offers no reason for thinking that such nucleosides exist. Then we turn to paragraph 324. The judge says, I also consider all that example 31 is saying in relation to examples 2 and 7, at least with any clarity, is that they provide methods that may be used. I don't see any teaching in example 31 to go back and redo example 2 or example 7 with the exact RNA sequences disclosed there. And my learned friend's criticism of this paragraph is directed at the first sentence, where the judge says that example 31 is saying that examples 2 and 7 provide methods which may be used, whereas paragraph 290 states that additional modifications are introduced using the methods described in example 2 and 7. In my respectful submission, that's not the point that the judge is making, as can be seen from the second sentence. What the judge is doing in paragraph 324 is clearly rejecting Pfizer BioNTech's case that example 31 teaches the reader to make all 5 RNAs. That is what the judge is doing in paragraph 324. We then get to the findings in relation to individualisation. First of all, paragraph 325. The judge finds that M1 psi is present in black and white in the middle of the list, but he says that doesn't of itself make it individualised, as is clear from Dr. Reddy's. We don't need to go back over the principles that emerge from paragraph 31 of Dr. Reddy's, the question being a matter of degree and other considerations coming into play. So when the judge says, as he does at the end of paragraph 325, I don't find there anything shocking in the rejection of 1 amongst 96 as not being individualised. And in any event, the list is in fact open-ended. The judge, in my submission, is simply finding that in the context of this case, and that includes the woolliness of the teaching in example 31, even if the list of nucleosides was limited to 96, that would be too long, but in any event, the list is longer than that. And my learned friends criticise that finding on the basis that if there is such a thing as a list being too long, and your lordships will recall my learned friend's submission that as far as the EPO is concerned, there's no such thing. But if a list is capable of being too long, then 96 can't be objectionable because of the finding of the judgment in Almirall. Now, in Almirall was a decision which preceded the Court of Appeal's judgment in Dr. Reddy's. And it was a case in which 159 example compounds, each of which had been synthesized, not only synthesized but then characterized in terms of their physical characteristics, their NMR and spectra and so on. And in my submission, individualization is not simply a numbers game. Individualization is a matter of degree, and one simply cannot reach to one case where, on different facts, a given list was held to be sufficiently short to be individualized, and say, well, if I'm less than that, then I must be individualized. It's much more nuanced than that. Because after all, context, which is common ground between the parties, is relevant to the question of individualization. Then in paragraph 326, the judge considers the position if an open-ended list of 96 is not too long for M1 side to be individually disclosed, or if the woolliness of the teaching of example 31 is not a reason to reject the individualization case. And even then, the judge rejects the case that there is no selection, no need for a selection from lists. And he says if M1 psi is individualized, only in the sense that it's one of a long list with no preference, so that's list 1, and then list 2, the RNAs. In an example for claim 3, that would mean one of the messenger RNAs that are identified there. And my learned friend said yesterday that your lordships can disregard the second half of paragraph 326 because the judge was only looking at claim 5. I don't accept that, because one can see in the last four lines of paragraph 326, the judge says to get anticipation it would be necessary to take M1 psi and use it with an mRNA of example 2, specifically RNA 18666 for claim 5, or RNA 1571 or RNA 730. Now, because the judge is referring to 1571 and 730, and also 1866, he is necessarily making a finding that is applicable to claim 3. Now, I accept that when the judge then goes over on to the next paragraph, paragraph 327, the judge is definitely there focusing on claim 5, because he said at the end of paragraph 326, since Pfizer BioNTech need to knock out claim 5, the key question is over RNA 1866. But the principle that he is applying in 327 is also applicable to claim 3. And just, my lord, I've just been asked to remind your lordships that there are 5 RNAs which are identified in example 2. 4 of them are messenger RNAs, although one of those was too small to have been tested. So there were 3 messenger RNAs which were tested in example 2, and then there is one RNA which is an antisense RNA, and therefore is not a messenger RNA. And that is reflected in the judge's findings in paragraph 314. Going back to example 2, Pfizer BioNTech say that 5 RNA sequences are disclosed, of which RNA 1866 is an mRNA that has a poly-A tail. It should be noted that none of the other 4 has a poly-A tail, and that RNA 713 is not a messenger RNA but an antisense strand. And then at the top of page 117, under little Roman 6, RNA 497, which isn't mRNA, was also not in fact tested in example 2, given that it is shorter than the minimum length indicated at line 20. Now, if I could ask your lordships to turn back to paragraph 318. The judge is explaining the circumstances in which route 2 comes into play. He says route 2 is a variant on route 1, comes into play in case I should conclude that a selection from the RNAs in example 2 is needed to get to claim 3, as opposed to each of them being disclosed in combination with each of the 96 options from paragraph 291. Now, route 2 is no longer pursued by my learned friend. But what he says instead is, well, actually any messenger RNA will do. So, contrary to his original case in relation to route 2, which is that there's a disclosure of all 5, contrary to the premise of route 2, which is there are sufficient pointers to the particular messenger RNAs which are listed in example 2, he's now embarking upon a brand new case that involves reaching for a skilled person being taught to reach for any messenger RNA. Now, my submission, that is a distraction from the real vice of example 31. It's a distraction from the real vice on both formulations that my learned friend advanced yesterday. That is to say, clear and unmistakable directions which would result in something falling within the scope of the claim, or clear and unmistakable disclosure to do example 2. Because what we have in example 31 is a list of nucleosides. A list of nucleosides in respect of which there is no technical teaching, in the sense that their properties, whether in terms of immunogenicity or translation, are nowhere disclosed. The instruction is to test additional nucleosides, but that's not a specific instruction in relation to any particular compound. It is an entirely general instruction, one which is capable of being effected in countless ways, the vast majority of which will not involve M1 psi. And my submission is that that analysis of example 31 is akin to Lord Justice Jacobs' analysis in Dr. Reddy's. And we don't need to take Dr. Reddy's itself, but if your lordships take the judgment, and turn to page 75, we see the beginning of the citation by Lord Justice Jacob. And then, yes?
Sorry, page 75.
75 of the judgment. Sorry?
Bundle page 70.
The bundle reference. Would it be easy if I gave your lordship the paragraph number? Paragraph 127 of the judgment of the appeal.
I'm sorry, I was in the actual Dr. Reddy's original. Sorry.
Oh, I see, I'm sorry.
Yeah, sorry. Okay.
I was trying not to jump around too much between the
Sorry.
bundles.
75.
So page 75, we see the long citation that we've looked at in some detail already. We looked at paragraph 31, and then in paragraph 32, Lord Justice Jacob explains that this view of the law accords with the decision of the House of Lords in Sintron. He then explains, or refers to paragraph 22 of Lord Hoffman's judgment, which we've looked at before. If I may summarise the effect of these two well-known statements, the matter relied upon as prior art must disclose subject matter which, if performed, would necessarily result in an infringement of the patent. And Lord Justice Jacob goes on to say, where you have a patent for a particular chemical compound and a prior art general disclosure, performance of the general disclosure, which means no more than using anything within it, does not necessarily result in infringement of the patent. In this case, for instance, you can perform 235, which was the prior art, in any of 10 to the 19 ways. Only one of them would result in infringement of the later patent. Now, plainly, the numbers are different. It's not a case in which there are 10 to the 19 compounds listed in example 31. But the principle is directly applicable to the case which is before your lordships. There is a general disclosure in example 31, not a specific instruction in relation to any particular modified nucleoside. And that instruction is capable of being carried out in many, many different ways. Well, that is the beginning, the middle, and the end of Route 3. That really is the bottom line in terms of its teaching. And then one last point. In paragraph 329 of the judgment, the judge returns to the principle that he has previously identified in 139. Now, I accept in paragraph 329 that he is now focusing on claim 5, but his analysis applies equally to claim 3. So even if there is a pointer to messenger RNA, that is in the context of a disclosure in which there is no pointer to messenger M1 site. Well, that completes my submissions on the novelty of the two routes. If I can be of any assistance.
I've only got one question. You touched on it this morning in your reference to the European Patent Office document we were given. And it's the paragraph that appears under the heading multiple selections identified.
Yes. Can I just try and find my... Yes, no.
It says a list is usually considered to have a, quote, certain length. And then the paragraph concludes, similarly, merely reducing the length of the list does not generally confer novelty if their length is not reduced below the required length, which seems to be something which is also dealt with. Can you just, for a novice, can you just try and unpick that paragraph and tell me what is actually meant by certain length or required length, if it's not just saying this is all dependent on the facts of a particular case?
Right. Well, I think that paragraph is reasonably coherent
Okay.
until one gets to the last sentence.
Right, okay.
Merely reducing the length of this doesn't generally confer novelty if their length is not reduced below the... Look, I'm going to find it difficult to make a coherent submission in relation to that last sentence.
So it's not just me?
No, I'll just ask. Right. Let me just read that. Maybe reducing. Yeah. Okay. Well, my learned junior says it's very clear to him, which it simply means.
Well, as long as okay, I don't
I'll
mind.
tell you what.
Perhaps he can explain then, because I just find it difficult to follow. That's all.
I think it means well. No, I'll let him explain it rather than. I think he may have a clearer account of it. Well, you've got it. Yeah.
In rugby parlance, that's a hospital pass, I think, that's the expression I heard.
Yes.
I'm grateful, my lords. To take that point straight away then, I do accept that it's not written in the clearest language, certainly, my Lord Justice Snowden, but my understanding is simply that it's not enough for somebody to say there must be novelty because I've shortened the list, because even the shortened list may offend against this rule. So it's not enough to say I've made a selection because I have produced a shorter list. You've still got to examine in light of all the facts and in the usual way. But it certainly does come back to the point that my Lord drew attention to, which is it's all a matter of fact and degree in the context of the facts before the tribunal. Simply shortening a list isn't enough, is all I understand that paragraph to say, without more.
Okay, thanks.
And with that, if it pleases, I propose to say a few words of introduction about the response to the obviousness appeal at a very high level, and then propose to deal with matters in more or less the order in which my learned friends have addressed them in writing. And I'll pick up points from yesterday from my learned friends' oral submissions as I go. So we start, if it pleases, with what the judge found in relation to obviousness, and as indeed my learned friend said yesterday, the kernel of that reasoning is at paragraph 415. So if we can perhaps walk through that paragraph relatively slowly to start with. That's at page 133 of the core bundle behind tab 5. So the judge starts, I must assess all these matters in the round. So first, the judge is clear and correct that this is a global assessment that must take in all the relevant evidence, and that's a point to which, of course, I will be returning. Then he says, doing so, I find that Pfizer BioNTech's attack of obviousness fails, and it's not a close call either. So pausing there, this serves to magnify just how steep is the mountain Pfizer, and I will call them Pfizer compendiously without meaning any disrespect to anyone, have got to climb on obviousness. They seek to upend substantially the entirety of the assessment of an experienced judge who saw the witnesses and appraised their technical evidence over the course of days and reached a conclusion that the obviousness case was not at all one that was close to the line. Then he says there is no special pointer in UPenn to try other pseudo-European modifications, and the focus on paragraph 56 is artificial and hindsight-driven. Now, my learned friend Dr. Ackland has dealt with the construction of paragraph 56. I won't retread that ground, but I shall look at the remainder of the point for the purposes of obviousness in due course. Then the judge goes on, and I wonder if my lords could just read to the end of the paragraph, please.
Yes.
Now, we'll unpack that in due course. I'll assist you with it in more detail, of course, but certain observations to be made up front about the nature of the assessment the judge was doing. We say ultimately that the judge's conclusion there, 1, is founded firmly in the evidence, 2, plainly includes those aspects of the evidence relied upon by Pfizer, such as, for example, the Charette and Gray article, 3, didn't hang on any single factor, such as expectation of success, but rather a combination of factors as part of a whole story that the judge heard about. And 4th, relies in part, but not entirely, upon his assessment, the judge's assessment, of what he saw to be Dr. Enright's approach to his evidence. So absent a clear error of approach in principle by the judge, unwinding all of those several aspects that he wove together is a task that's all but impossible fairly for an appellate tribunal to do. And that is why the law is clear that an appellate tribunal will not generally reverse this sort of multifactorial finding, absent such a clear error. So next then, it's perhaps valuable to focus just for a moment, before we go to the detail, on 2 things you have not heard from my learned friend on this appeal. In relation to obviousness, the first one is law. We haven't heard very much reference to the law to support my learned friend's case on obviousness at all. In truth, that's because there is no proper error of law identified by Pfizer BioNTech. The only candidate advanced relates to the expectation of success, but my learned friend's ground of appeal and his skeleton, for example, and you can just take it from me, that paragraph 86D of his skeleton says in terms that this is a matter of weight. They don't advance a case the judge was wrong to take account of the expectation of success, merely that it's a point to which the judge should have accorded less weight. Similarly are paragraphs 133 and 142 that expressly term this a question of weight. The second thing you've not been presented with by my learned friend in the course of this appeal, importantly, is that you've not heard a coherent story of the evidence as a whole that takes account of these individual findings that Pfizer would have preferred were made differently. And that point is particularly important. The judge under obviousness, as we've seen, had to make a global assessment of all the relevant circumstances. And on appeal, Pfizer asks you not to do that, but to zero in on one or two isolated aspects of the picture that they would rather have changed. Taking each of those factors entirely acontextually, and without considering their part in the story that the judge saw from the documents and heard from the witnesses, is not a fair basis on which to ask this judge to revisit what the judge found. Ask this court, excuse me, to revisit what the judge found. And that's because, as my lords are well aware, and as Lord Justice Lewison has memorably put it before, this court is necessarily just island hopping through the evidence rather than being able to appreciate the sea of all the evidence the judge was surveying. So when it comes to the skilled person, for example, which is the first issue I'll take in detail in a moment, it's not suggested that when he cited and relied upon the structured assessment coming from the Illumina case, the judge identified the wrong law. Nor is it suggested that Illumina itself is an incorrect statement of the law. So Pfizer accepts, or at least has not advanced any case to the contrary, that the judge adopted the right legal approach. It just thinks the judge should have thought their expert was a bit more personally relevant, and that the skilled person should have been more aligned with his personal experience as a fundamental scientist, not concerned directly with any applications. Similarly, in relation to the expectation of success, as we've seen, they make no suggestion that the judge was wrong to consider it as part of his global assessment, nor do they suggest that the judge wrongly understood and applied the concept of what an expectation of success means in this case. It would be surprising if they did. The beginning and end of Pfizer's submissions on this are clear. It's all just a question of weight. So to conclude on this overview, the 33,000-foot view, before we tackle the topics individually, my overarching point is singular, and we do say it's fatal to the obviousness appeal. None of Pfizer's objections is a point which, even if they had any force, which they don't, is a proper basis for an appellate reversal. So with that, I'll take the topics in some more detail, starting first with the skilled person, which goes to grounds 1 to 3. My lords, the judge considered the law in depth over 5 pages at paragraphs 103 to 117 of the judgment, but I don't propose that we turn that up because there's no dispute as to any of that analysis. Indeed, those paragraphs aren't even mentioned in Pfizer's submissions under this head. As for the assessment on the facts of the appropriate skilled person, we do need to look at that. And the judge dealt with this at paragraph 256 onwards. So if it pleases, can we turn that up? It's on it's on page 101 of the core bundle behind tab 5. So he starts out at 256 setting out the parties' rival positions. Moderna had put forward a skilled person who was specifically working in transcript therapy. Pfizer had put forward a skilled person who was working in a series of subfields to which we'll return. And furthermore, which was looking at them either for applied or fundamental research purposes. The judge's conclusion, to cut to the quick, is at 263 on page 103, and it's there he makes his finding as to who or perhaps what the skilled addressee of the patent is. It's fair to note that that is neither of the respective submissions of the two sides, so let's look at how the judge got there. So we started at 256, where he set out the parties' positions, and then 257 to 258, the judge quoted and discussed the parties' closing skeletons on this, and showed a degree of commonality of the scientific elements of the problem. But then at paragraph 259, that left the important question, well, for what purpose is the skilled person interested simultaneously to improve the translation and immunogenicity of mRNA? Moderna had said, again, it was for transcript therapy only, and Pfizer had said it was for someone in any of the series of subfields set out at 260, but including someone in those fields interested in fundamental research. Now, as he recorded in 259, the judge rejected both of those submissions. He rejected our submission as too narrow. One can see that from the start of 260, not limited to transcript therapy, based on the evidence that he'd heard. And he then rejected Pfizer's submission as well at 261. That was because, in light of the evidence, he found Pfizer's submission was not a fair way of looking at things, and the evidence did not support the position that the correct field was one of pure research, whatever its scope. Now, the important thing about the list under 260 is this series of subfields which the evidence, and I stress that again, the evidence had established to be ones in which solving this scientific problem would be useful, but there are 2 points about it to emphasise. First, the labels given to the subfields under 260 are, as is clear from what the judge says, labels accorded to them by Pfizer. So for Pfizer to try and make a sort of circular argument saying, well, we called these fields research, therefore they must be pure research, therefore the skilled person must be a pure researcher, doesn't work. But second, and perhaps more importantly, the labels accorded to these subfields cannot trump the substance of what the judge gleaned from the evidence about what the skilled person would be doing. As to that, we see the second half of paragraph 261, where he says, Pfizer BioNTech described some of the above fields as study or research. That tended to favour its argument that Dr. Enright was close or closer to those teams, and this is, but I think that is not a fair way of looking at things. The above teams were looking for practical results, and I do not think an overview of them supports the position that the correct field was one of pure research, whatever its scope. So 261 makes clear that the judge finding the right skilled person by reference to the list under 260 is excluding from that list anyone who is engaged in fundamental research. He says that in terms at 261. So the skilled person is someone who's working in one of those subfields in 260, but only to the extent they're a person working on practical or applied research and not fundamental science research. So the judge's formulation, as we've seen, comes at 263 for the skilled person. And the upshot, though he adopted neither of our submissions as to who the skilled person would be, was indeed in favour of Moderna, as the judge said at the end of 259. As to that yesterday, there was some talk about whether it was inconsistent with what he'd found in 260 and 261. It's not inconsistent at all. The judge didn't say his conclusion was more in line with Moderna's submission on the skilled person. He said it was more in Moderna's favour. And so it was. The fact that the skilled person would be looking for real practical results is an important part of the inventive step case on which Moderna prevailed. So he picked a skilled person that was neither of our submissions, but the one he picked was indeed in Moderna's favour, as the result on this head of invalidity makes clear. Most importantly, though, I come back where I started. All of this analysis, again, springs from what the judge thought of the evidence. Taken together, paragraphs 261 to 263, or indeed 257 to 263, show that the judge reasoned from the evidence to his conclusion on the appropriate skilled addressee, and it was a finding with basis in that evidence. He recorded and considered Pfizer's contention that the skilled person should include a fundamental researcher, interested in understanding translation and immunogenicity of RNA modifications purely for the sake of being interested, but he rejected it on the basis of the evidence. He said it was not a fair way of looking at things based on what he had seen and heard. So, my lords, that being the structure of the analysis, there's no basis for an appellate interference here either. Of course, the real driving force behind Pfizer's objection here is the one that the judge anticipated at paragraph 265. He found there was a variety of subfields of research where this invention was of technical import, and Pfizer had sought to criticise Moderna's expert, Professor Rosenecker, on the basis that he was only from one of them. As the judge went on to find, any researcher was likely only to be from one of those subfields. Of course, the problem for Pfizer was, once the judge had made the finding he did in 261 and excluded fundamental researchers from the skilled person, its expert, Dr. Enright, was an outsider altogether. And so Pfizer really seeks to take issue just with the judge's conclusion about the skilled person, rather than any points about his approach in law to the issue, or just to rehabilitate the relevance of its expert. So, my lords, there's no inconsistency in the judgment on this point. It starts from we're agreed the correct law. It then moves to the evidence and reasons from that evidence to a conclusion that it hasn't been suggested properly is irrational. There's no basis to go behind it. But my learned friend does go further in his skeleton and says that the judge was wrong on the evidence to find that the skilled person would not be a person whose interest was in fundamental research. But there are two problems of principle with that submission. The first we've already seen. The judge didn't just reason his way to this finding as a matter of principle. As he emphasised in his unchallenged survey of the law on the skilled person, the assessment involves a degree of value judgment. So on page 72, paragraph 115 of the judgment, this is part of the judge's unchallenged survey of the law on the skilled person. The judge quotes from our opening skeleton argument a passage with which Pfizer agreed. And my lords will see just above subparagraph B at the bottom of the page there is therefore an element of value judgment in the assessment of the skilled person. So the assessment involves a degree of value judgment, and in reaching his value judgment, the judge correctly based himself in what the evidence told him about real skilled teams. And that's an unchallenged part of the law as well, that is what the judge should be doing, from a case called Schlumberger. Second, as the judge acknowledged at 266, there is in any event a principled difficulty with a fundamental scientist being the skilled person of patent law. As is clear and now uncontroversial, the skilled person is someone with a practical interest in putting the invention into effect. Not just someone with an interest in the sense of intellectual curiosity about the invention or how it works. And as we'll see in a moment on inventive step, the fact that Dr. Enright was a basic scientist and thought the skilled person would be too, meant that he was interested in obtaining results even for things which he thought were likely to be catastrophic, that's his word, in terms of their prospects for taking forward to any useful application. As for the finding that Dr. Enright himself was a pure basic researcher, that's paragraph 51 of the judgment. If I could just ask my lords to remind yourselves of that, please. So on the evidence, it was found that he really was at the pure research, fundamental science end of things. And to such a basic scientist, and I really don't use that term pejoratively at all information is good information. The definition of success is just finding out anything instructive perhaps, even finding out that there's no way forward, that any useful application of the work is entirely hopeless. The world is better if we know more. If we adopted so permissive a definition of the skilled person for the purposes of patent law, the entire structure of the obviousness analysis collapses. Asking what would be obvious, or what that skilled person would feel motivated to take forward, becomes meaningless. He or she wants to take everything forward, or anything forward, because all results, positive or negative or even catastrophic, are interesting. That simply cannot be the right approach in law, in the scheme of the Patents Act, and so it's for very good reason that the law requires of the skilled person, as the judge properly recorded and then applied, that he or she have a practical interest and that it be in putting the invention into effect, not just understanding something about it. My lords, all of this is encapsulated, we say, in paragraph 266 of the judgment. And if I can ask my lords to read that, my central submission about it is that it's correct and compelling.
Yes, thank you.
So in contrast to what the judge has said and which we endorse, Pfizer BioNTech's position reduces the meaningful role of the skilled addressee too much. Because
so I understand the point you're making, and in a sense it's relevant to some of your other submissions more to this one. But I did ask Mr Mitchison about technique, and I would be grateful for your submission on that.
I'm glad to hear that, my lord, because that's the next topic in my note.
Very good. So take it in your own time.
I'm grateful, my lord. Pfizer's submission was never quite put this way, but really it amounts to reducing the skilled addressee of a patent to anyone whose background might make them curious to read it, and we just say that that's wrong. An additional and related point is the one my lord alights on the interaction between the skilled person and the expert witness who's giving evidence about them. My learned friend says that the relevance of Dr. Enright's personal experience is questionable, relying on coflexip, and the nub of the passage he took you to from coflexip is relatively straightforward.
Be explained for those who don't know that that's the same case as technic.
Excuse me, my lord, yes, indeed. We will be going to it in a moment anyway, so that will become clear, but I'm grateful.
It's very confusing because the reports of patent cases don't identify the parties that are commonly understood to have been involved.
That's a very fair observation, my lord. I'm sorry for not making it clearer, but coflexip and technic certainly are the same case, and we will be going to either or both in a moment. The point my learned friend made was that the relevance of Dr. Enright's personal experience is questionable, relying on paragraph 12 of that case, which we'll look at. And the nub of it was, look, a patents trial isn't a contest to see whose expert best approximates the skilled person. But let's briefly look at it, please. So it's at Joint Authorities Bundle, tab 4. JA1, I'm grateful. And we're looking at paragraph 12 on bundle page 177. Paragraph 12 says this: I must explain why I think the attempt to approximate real people to the notional skilled man is not helpful. It's to do with the function of expert witnesses in patent actions. Their primary function is to educate the court in the technology. They come as teachers, as makers of the mantle for the court to don. For that purpose, it does not matter whether they do not approximate to the skilled man. What matters is how good they are at explaining things. Now, as far as goes educating the court about the technical issues, the primary purpose of an expert, as Lord Justice Jacob put it, that, of course, is right. But an expert witness's function is not limited to that primary purpose. It's common ground that the skilled team is to be assessed by reference to how real research teams in the field were composed and how they would have behaved. Let's illustrate this with an example. For some obviousness cases, understanding a general sense of a prejudice that the field had, even one that in hindsight might appear to be unreasonable or scientifically unjustified, that prejudice can be relevant to the analysis. In the appropriate case, it can be decisive, overcoming a prejudice of the field, showing them that they had been wrong not to want to go in direction X, may on some facts be the basis of an invention. And the basis for that sort of finding, of course, must lie in the evidence. Now, often, that sort of prejudice, of course, won't emerge directly from the literature. People don't write peer-reviewed papers about things they declined to investigate because they had a sense it wouldn't be any good. Instead, appropriate experts come to court to help with this by relating a sort of factual evidence, perhaps explaining their experience of this prejudice through discussions they had on the fringes of conferences or exchanges they had with a distinguished colleague, something like that. Of course, that sort of evidence, that sort of information, can only ever come from someone who was actually there, someone who can tell the story of the field from the inside. Now, the judge here had clearly in mind that experts have those two distinct functions, as is readily apparent from his paragraph 66. If we could turn to that, please. He says, we'll return to the hindsight submissions in a moment, but based primarily on the second and fourth points concerning Dr. Enright above, I consider that Professor Rosenecker was a more useful witness in helping me to understand how the skilled person would think and reason at the 949 priority date. But both witnesses were helpful in assisting me to understand the technology involved. So as far as Lord Justice Jacob's primary purpose goes, educating the court about the science, Moderna didn't submit that Dr. Enright was somehow unqualified to deal with that, and the judge certainly didn't find so. He found them both to be helpful. But when it came to understanding how someone in the field would think and reason at the priority date, something else he had to consider, inevitably, given the findings he'd made about what the field was for the skilled person, he preferred the view of Professor Rosenecker in the field to that of Dr. Enright, the outsider. And in this case, it's relevant because, as we'll return to, the judge found that one material part of the inventiveness story was the fact that the subfields where researchers were seeking to apply RNA modification had not much got off the starting blocks for several years. The evidence was that in transcript therapy, for example, there were no candidates, and in oncology, although there had been candidates, there were no successes. So the resulting sense of frustration, plainly, in my submission, relevant context the judge was entitled to consider for assessing how such a skilled person might react when finally they're presented by the prior art, giving a compelling account of an excellent new option. Dr. Enright could never assist with that. He could never assist with how the members of any of those subfields, as found by the judge excluding fundamental researchers, would react, because he just wasn't there. So that brings us to a close on the skilled person. The rest of Pfizer's points in writing simply seek to quibble with the judge's findings by referring to other things that Dr. Enright said. But the judge took account of all of the evidence and dismissed those points. He also took account of the contrary evidence from Professor Rosenecker, who really was in the thick of the transcript therapy field at the time, and by whom we say he was plainly entitled to be persuaded. So that deals with the skilled person in grounds 1 to 3. unless I can assist any of my lords further with those. I'm grateful. In that case, grounds 8 and 9, paragraph 56 of UPenn and the hindsight allegation. As I said, my learned friend Dr. Ackland has dealt with the appropriate understanding of paragraph 56, and it would be more than my life is worth to try and traverse that ground again. So you have our submissions on how it's properly to be understood in line with the judge and his approach. The remainder of the point for the purposes of the obviousness appeal is that in essence, Pfizer complains the judge was wrong to characterise Dr. Enright's approach to his evidence as tainted by hindsight. And that's been said several times to be both wrong and unfair. As we will see in due course, in fact, it is neither. But in any event, the judge was bound to assess the expert witnesses he heard from and to consider the extent to which their approach appeared to be in line with the notional skilled person in 2010, who plainly doesn't know anything that happened afterwards. We say the judge had a clear basis for his findings about Dr. Enright's approach, and he set it out in the judgment, as we'll see. So in my submission, one could stop there. I will go through the detail, but really my prime position is that's the end of it. My learned friend yesterday to point at other evidence from Dr. Enright and say, well, it supports the view he prefers, is neither here nor there, even if he were right about those isolated passages. The judge's finding is one he was entitled to reach, having heard all of that evidence. So to the basis for the judge's approach on this, he set it out at paragraphs 52 to 63 in the judgment. And his finding that there was material hindsight is based on 3 factors. And we explain these as well in writing at 105 of our skeleton, which I don't propose to turn up. The 3 factors are first, paragraph 60 on the bottom of page 59, in relation to Dr. Enright's explanation for the inclusion of M5D in that list in paragraph 56 of UPenn, notwithstanding that in fact it isn't a pseudouridine in the scientific sense. We'll return to that and the significance of sequential unmasking in a moment. The second point was Dr. Enright's reliance on a paper cited in the RNA modifications database called Brand et al. From 1978, which he reached for in his oral evidence in a way entirely inconsistent with how he had said the skilled person would deal with references in that database when he was considering another entry, namely that for pseudouridine. And the judge records that in paragraph 61. Paragraph 62 then, the judge relies on what he perceived to be Dr. Enright's heavy focus on paragraph 56 relative to 291. And just to cover off something my Lord Justice Arnold asked about yesterday, my Lord asked if there was an antecedent to paragraph 62 because the reference to 291 at this point rather comes out of nowhere. My Lord, I'm afraid the short answer is probably a boringly practical one. It doesn't have an antecedent in the literal sense as coming before it, because this is just the witnesses section of the judgment. And so the judge needs to appraise the witnesses in the context of the issues, but hasn't yet explained what those issues are. But for my Lord's notes, the finding to which we say this comment relates when the judge does tackle the substantive issue is at paragraph 379, Roman 5. That's a paragraph you've been shown before, in which essentially the judge finds that taking the document as a whole, he considers there's no reason for the skilled person without hindsight to jump to paragraph 56 as some sort of starting point, rather than 291, which is also available.
But to be fair to the judge, he does tell you in paragraph 33 that actually you'd be better off going to read the rest of the judgment first and then come back to that section.
That's a very fair observation. I hadn't found it in that paragraph, but I suppose I'm saying the same thing. I wanted to answer my Lord's question from yesterday. There isn't an antecedent, but that's what it corresponds to. But
if you do what the judge tells you, you would know what paragraph 291 was.
Indeed. It's an antecedent if you follow the instructions. I suppose that's right. Anyway, there are the three bases at judgment paragraphs 60, 61 and 62 for his finding that there was material hindsight. Each of those is an impression that the judge was entitled to form of Dr. Enright and his evidence, and it's one which it would be very difficult for this court, who will not see or hear from Dr. Enright, to look behind. Now, the first and second were directly advanced by Moderna, And the third is part of the impression that Dr. Enright made on the judge, who was, and was bound to, assess the evidence given. Now, my learned friend, again, notwithstanding that we pointed to this in our responsive skeleton, didn't address the second factor, brand, at paragraph 61, at all yesterday. So we can take that as read, and I will also focus on numbers 1 and 3, but I'll spend some time on the sequential unmasking point first. So the judge accepted at paragraph 54 that, in general, as he put it, Dr. Enright's evidence had followed a sequential unmasking approach. That's to say, they were asked about the common general knowledge, then shown the prior art, and only then shown the patent. Sequential unmasking in this way is a useful procedure to guard against hindsight at the initial stages of working with an expert. But my learned friend talks of it as if it were some sort of magic wand, which, provided it's followed, not just relieves the judge, but bars him from forming his own impression of how the witness approached all of his evidence before or after knowing about the patent. The judge, though, explained carefully and correctly at paragraph 55 why that is not so. In short, the judge has to assess the totality of the witness's evidence, the oral evidence and all the written evidence. Necessarily, some of that, and indeed all of the reasons that come out in oral evidence, are necessarily being produced after the witness knows about the patent. That's not a criticism of anybody, it's unavoidable. And we'll see in a minute that the judge makes this point again later on. The expert can give their overall views on broad issues before seeing the patent to the legal team, of course. But the detailed reasons that appear in his or her report continue to be put together after they know what the patent is. As does, of course, necessarily any reasoning that the expert deploys in the witness box in response to a question. So paragraph 55, where the judge says that not all of the main elements or details of the report will have been arrived at before Dr. Enright knew that M1 psi was the answer, isn't inconsistent with 53 and 54 at all. 53 and 54 go to that part of the evidence prepared before the witness knew of the patent, and 55 deals with the fact that some of that was come up with, perfectly properly, after he knew about M1 psi. And I respectfully ask my lords to bear in mind as well that my learned friend yesterday placed considerable emphasis on his submission arising from the Coflexit Technip case, that it's not really the broad conclusions that matter, but the detailed reasons that he or she gives. Those are all the more likely to emerge or be added to later on in the process. There is nothing at all wrong in the judge considering whether material hindsight has crept into some of the witness's evidence, even having accepted that at those initial stages with this witness it wouldn't have done because of the sequential unmasking procedure. As to the suggestion that this was not put to Dr. Enright, the allegation that his evidence involved at least some hindsight was squarely put. My lords could take the supplemental bundle, please. Tab 16, page 273. And we're looking at page 311 internally in the transcript. I'm going to start at line 7. What's happening here is Dr. Ackland is cross-examining Dr. Enright as to why it is that he, in the paragraph of his evidence dealing with the species that are listed in paragraph 56, says, well, the reason why M5D might be included, notwithstanding that in fact it isn't a pseudouridine, he was giving some evidence as to that, what the reason for it might be, and he linked it to its similarity to M1 psi in particular. And what was put to him, as we'll see, is the only reason you alighted on M1 psi, or a reason you alighted on M1 psi in particular, is because by this point you knew that was the answer. What I'm trying to understand, Doctor, says my learned friend Dr. Ackland, is why you referred in paragraph 716 to the similarity between M5D and M1 psi in particular. The witness asked to clarify the paragraph. I don't know if there's a particular reason, but yes, it does share similarities with M1 pseudouridine. Did you refer to M1 psi because at the time of actually finalising this report, actually you did know this case was all about M1 psi? And the judge says he doesn't think that's the case. Then, on the 10th of January this year, you knew that this case, that's the date his report was signed, you knew that this case was about M1 psi. On the 10th of January this year, I knew that was the case, yes. What I'm suggesting to you is actually the reason why you referred to M1 psi in this paragraph is because actually it has crept into your thinking. I would disagree with that. So, certainly the witness didn't accept it, but it was put. My learned friend's point can't be that the hindsight allegation wasn't put. Rather, he's complaining that it wasn't put broadly enough or often enough. Two submissions on that, my lords. First, it's neither practical nor desirable that instead of putting some examples of hindsight thinking as the foundation for a submission to the judge, every single instance must be separately addressed. Cross-examination in patents cases would take very materially longer if that became the rule. Second, Moderna's submission was never that Dr. Enright's evidence should be taken out of account altogether because of hindsight. And indeed, that is not what the judge did. My learned friend yesterday several times accused the judge of, and I quote, excluding the evidence of Dr. Enright on this basis. But that submission, whilst repeated, was wrong. He did no such thing and was expressed that he was doing no such thing. My lords could turn to paragraph 64 of the judgment. Neither of these factors above is a personal criticism of Dr. Enright, he says. I accept his general evidence about the sequence of his instructions, but it is a reality of the system that his long and detailed report will have continued to be worked on after he did know about the importance of M1 psi, and it is an understandable thing that it affected the analysis. As to there being some general hindsight, this is a factor to take into account and not a reason for rejecting his evidence wholesale. So my learned friend's repeated suggestion yesterday that this evidence was excluded is simply wrong. The judge's analysis of hindsight thinking was entirely proper and considered, and ultimately it was a point that simply went to weight, based on his appraisal of the witness that he saw and heard. So once again, that's the quintessence of a point that's no basis for any appellate intervention. My lords, unless I can assist you further on that point, I was proposing to move to the expectation of success and ground 7. I'm grateful. There is no room in my submission for an argument that as a matter of general principle, it is wrong under inventive step to have regard to the expectation of success in relation to options alleged to be obvious. Lord Hodge was clear for a unanimous Supreme Court in the ICOS case, to which we've both referred, that that's a relevant factor. For my Lord's notes, we don't need to turn it up because I don't understand that to be in dispute, but it's paragraph 65 of ICOS in particular. And that's tab 14 of bundle JA3 at pages 639 to 640. So the question for this judge was, is the expectation of success something he was entitled to treat as a relevant consideration in the context of this case and its factual story? The problem with Pfizer's approach on this appeal is that it hasn't given, my lords, the whole of that story. My learned friend has isolated the point from the very context that shows why it was material. The factual context starts with a field where there had been no successes. The judge records this finding in the judgment at paragraphs 365 to 366. It's page 124 of the core bundle behind tab 5. He found that the point wasn't so powerful as we would have liked it to be, but it still was a point in our favour, pointing away from obviousness. So we start with a field that's had no successes for some years. We then move to a prior art document in UPenn that presents a single option as being excellent. If we could just turn up UPenn briefly in the supplemental bundle at tab 2. Paragraph 246, which is on page 146 of the bundle, and my Lord Justice Snowden, I think that's 147, my Lord. Supplemental bundle, tab 2, 147, and has 00246, paragraph at the top. To summarise the previous two examples, the three advantages of Psi mRNA, so not a reference to the word pseudouridines, whether defined somewhere else or not, but Psi mRNA compared with conventional mRNA, namely enhanced translation, increased stability and reduced immunogenicity observed in vitro, are also observed in vivo. Dr. Enright accepted that the skilled person would see that as a fair summary, and he also accepted the overall message was that Psi was the best and outstanding modification. Indeed, he also accepted that in the context of their work, they'd stop work on anything else once they saw good results with Psi. My lords can see that perhaps most easily in a document to which my learned leader took you earlier, in the supplemental bundle at tab 7, please. This is Annex 1.
Can I just take you back for a moment?
Yes.
You made the point when you took us to 246 that there was no reference to pseudouridine.
So do pseudouridines generally. So what I say is that's a paragraph specifically about the Psi modification.
Yeah.
It's not a paragraph about pseudouridines, meaning the list of things in paragraph 56.
Just looking at the title to where this comes from, the previous page.
Yes, so I'd say, and it was clear, reading those together, the evidence was that that referred to Psi, and it was a fair summary. It says pseudouridine and not pseudouridines in the title of example 14. And here we say it's clear from the use of Psi in 246 that they mean that modification in particular, and not pseudouridines more generally.
It starts off in 242.
Yes, 244 and 245. And as my Lord Justice Arnold says, it starts at 242. I don't understand to be any dispute that this example, and certainly the conclusion at 246, is a conclusion about the Psi modification. And that might become a little more clear. If we turn to tab 7 in the same bundle, this is the document that Dr. Ackland took you earlier, prepared by Professor Rosenecker and agreed to by Dr. Ackland. Excuse me, Dr. Enright. I'm sure Dr. Ackland agrees with it too. One can see purely visually from the final column what's happening. They start off investigating a series of modifications, they get some great results, and they can see where the party is. It's all about Psi from there onwards. So we started with a field starved of success. They're presented with a document that it's agreed trumpets one excellent option, backed up by a compelling scientific account for why it would work. The expectation of success is relevant then because it goes to whether the skilled person in that position would take the excellent option they're given forward to see whether this would finally be an answer for their patients, or whether instead they would choose to ignore that message of the prior art and do something else, purely out of scientific curiosity. Would they instead move sideways and start making chemical changes?
In dispute, as is always the case, the fact that one option is obvious doesn't necessarily mean that other options are not obvious.
I accept that fully, as I'll come to.
So Psi is the obvious option, you say, and I don't think that's in dispute. But the argument is that doesn't exclude there being other obvious options.
But at that level, my lord, I don't disagree with it. What I do say is that the choice of what to do is always going to be made in the context of what options the skilled person believes they have available to them and what the expectation of success in relation to them is. When one is in a field starved of success for years and you're finally given something that works and a really compelling account that it works, it's plainly relevant when deciding, shall I do that or shall I do something else, to consider, well, do I think that something else might work or not? Do I have a reasonable expectation it will succeed? When I have a very good reason to believe this will succeed.
Your argument is you don't go off and do something which might well fail, unless, of course, you're a research scientist who's quite happy to find that out as an answer.
For example, exactly. So I don't say it's some sort of magic bullet. I don't say because psi is great, nothing else could ever be an obvious option. What I say in context is that it's absolutely fair and a completely real-world consideration for the judge to say the skilled person is going to ask him or herself, well, I've got a great option here. What do I think about the prospects of the other options before I consider what I'm doing? An important part of that is that the evidence was clear and agreed on this point that the skilled person would not learn from the prior art why psi had the excellent properties it did. So there's no rational basis on which to choose an alternative modified mRNA in the way that Dr. Enright thought his basic scientists would be curious to do. Now for him it doesn't matter, because as he emphasised, even if I think it's going to be catastrophic, I want to test it because more numbers is good for me. That's because he's a pure scientist, and the world is better for having people like that in it. This is not denigrating his work in any way, but it's not the work of a skilled person of patent law. Moderna contended that the skilled person could have no expectation of success, of failure, or anything in between in relation to such alternative modifications that Dr. Enright proposed the skilled person would test rather than taking psi forward. That's because he or she had no data about those alternatives and no understanding of how psi had the properties that they could try and extrapolate to choose something else. So as a motivation to go in a direction other than the first good option the field has had for years, it's plainly relevant to ask, are these alternatives likely to work as well or to be a dead end? And the skilled person at this point will say, I have no idea. So it's not a Brugger or Medicaid point. We don't say because psi is the obvious option, nothing else ever could be in principle. We say on the facts of this case, a skilled person in the real world would plainly take account of the lack of any expectation of success when deciding what to do. It just amounts to saying that a skilled person chooses what steps to take in the context of what options appear available to him or her and the nature and apparent promise of each of those options. My Lords, could we next go to paragraph 409 of the judgment on this? And could I just ask you to read that? This is encapsulating the points I've just made. And we say that 409 is right in the terms in which it's written. Yes, I'm grateful. Added to that is the point at the Judge's 410 immediately following, which is that there's a considerable amount of burden in taking any of these options forward. Indeed, as Dr. Enright accepted in his evidence, and the Judge alludes to here, the in vivo work necessarily requires sacrificing animals. So to take forward a series of options willy-nilly, without any good idea that they're going to produce anything useful, even leaving aside any formal questions of ethical or regulatory approval.
Well, hold on a minute. That's a difficult area which we've had to consider in other cases, and there's no hint of that being part of the judge's reasoning here, is there? I mean, he takes the point in 410 that this isn't something you would do lightly, and you can rely on that.
That's as far as I go.
He doesn't go any further.
No, I'm not making a point about the details of regulatory approval. I don't have that point. What I am saying is where he says he bears in mind that whilst they're not a huge amount of effort once set up, they include both in vitro and animal model experiments. And goes on to say, so the work in its nature, i.e. the nature of including animal experiments, would not be undertaken lightly. That's as far as I put it. I say the judge was absolutely right at that level to take account of that, and it's a further factor. But my lords, I put it no higher than that. My lords, the final topic on expectation of success. At the end of ground 7, my learned friend states that the judge was also wrong in his paragraph 417 to limit the application of the proposition in ICOS that it may be obvious to do routine but unpredictable experiments to situations in which it's expected that a routine experiment will yield a positive result. My learned friend made some short submissions on this topic yesterday, and so I do propose to pick up this point very briefly before I sit down. Let's look actually at paragraph 417, please. That's page 134 of the bundle, behind tab 5. And perhaps I could just ask my lords to read that, actually.
Yeah, well, we also need to read 418 where he gives his answer.
Indeed. So first, the judge accepts the proposition put forward by Pfizer at the high level at which it was put, but the point he then makes is a simple one that we say was absolutely correct. Just because a given method is a routine choice once you've decided to do a particular experiment, that doesn't make it routine to carry out any and all experiments using that method. You've got to decide what to do first, and the fact that you will have a routine method for doing it once you've decided what to test is accepted. But the first bit isn't. So it is here then. So although if the skilled person had a reason to test the M1-Psi modified mRNA, we accept the choice of method might then be routine. There's no suggestion that they wouldn't know how then to do the experiments. But the problem is, for all the reasons we've canvassed, and which the judge analysed in detail from the evidence, he or she has no reason routinely to choose to work on M1-Psi in the first place. Including, most importantly, that she has no rationalisation of why Psi performed as well as it did. So this is very, very different from the cases such as ICOS and the salt selection cases to which the judge refers there, where in those cases it's not just the method of doing the experiment, but the scope or design, what experiments to do, that can be characterised as routine. It might be a panel of salts to test as a standard thing, as well as having a standard method experimentally for testing them. Relatedly then, at paragraph 420, the judge found that the testing proposed by Dr. Enright and Pfizer would amount to a formidable research project. My learned friend yesterday criticised that by saying it was inconsistent with the finding the judge made at 417 to 418 that the work would be routine. But my lords can now anticipate what the answer to that is. First of all, let's look at what 418 says. None of this translates to the present case where the skilled person would not understand why Psi achieved what it did. The experiment formats proposed by Pfizer would be routine, but the planning as to what variants to test and according to what strategy would not be at all. That's the reason why it's a formidable research project, because you're making choices about what to test in the dark, because the prior art gives no insight about what it is about the one thing that you do know is an excellent option, why it's an excellent option. It teaches no particular characteristic or property of the molecule that the skilled person can seek to replicate or seek to achieve through the design of the experiments next. If my lords could just bear with me 1 second. My Lords, in that case, I'll very briefly just go through a couple of remaining points from the written submissions, but that will take me less than 5 minutes, I anticipate. The first point on obviousness in paragraphs 122 to 124 of my learned friend Skeleton is that the judge is alleged to have erred because such work on alternative modifications resulting in additional or similar benefits to those found for psi would have been useful. But that's not an error, my lords. Once someone has decided to do some work and has carried it out, the mere fact that that work product is then useful doesn't help with the question of whether it was obvious to undertake the work in the first place. This is the purest hindsight, judging the alleged obviousness of a step based on what information we now know it would yield. At paragraph 124 in that section, Pfizer refers to the judge's finding that example 31, that my lords have seen so many times in UPenn, comprised a positive teaching to look for other, better nucleosides. He did indeed make that finding, but as my learned friend Dr. Ackland has already explored in relation to novelty, there is no positive teaching in relation to any particular nucleoside or nucleosides. And second, we have the point that I showed you with reference to Annex 1, that the authors didn't do what Dr. Enright suggests a skilled person would do, but in fact they did the precise opposite. Once they saw how well psi performed, they stopped testing anything else and moved forward with psi alone. My lords will recall that final column in Annex 1, which all converges on the single psi character. The next point in writing at paragraphs 125 to 128 amounts to another submission that because basic research could produce an output that was informative or interesting, there is therefore a relevant motivation to do such basic research. And so that's the same hindsight fallacy as before, and I don't propose to say anything more about it. Finally, paragraphs 129 to 132 seek to unpick a finding of the judge about technical matters on which he heard evidence. This is the Charette and Gray paper, again isolated by Pfizer from the broader context of the story of which it formed only a small part. The judge's assessment of the significance of Charette and Gray was detailed, correct, and properly contextualised. This was an issue the subject of complex scientific evidence, in large part oral evidence because of the stage at which it emerged, and the judge weighed it carefully. My learned friend in any event yesterday accepted that this was a pointer away from obviousness, and neither we nor the judge has ever suggested that it on its own, the Charette and Gray point, was some sort of magic bullet. So as far as my learned friend's appeal goes, that point, as far as I can see, has gone away. So the remaining points then at 133 to 143 are expressly and repeatedly made as a submission that the judges are said to have afforded too much weight to a factor in a multifactorial assessment, and I fear I've done to death now that makes clear it's not a proper appeal point. So beyond saying that, I don't propose to address it any further. My lords, unless I can assist you further in relation to the obviousness case, that concludes Mr. response.
Yes, Mr. Mitchell.
If I may, firstly start with the law on novelty and the submissions my own friend made to you on that. He started off by relying on the Wyeth case. He said that was contrary to the submission I'd made, but I'm afraid he misquoted my submission in seeking to rely on Wyeth. I said there was no case with a single black and white list in a single place, which was found not to individualise, which remains the case. Nevertheless, I'll deal with it and show you that the facts of that case are so far removed from the facts of the present that it can be of no assistance. So if your lordships would go please to JA Bundle tab 11. JA2 tab 11. And if we can pick it up on page 509 of the bundle, which is paragraph 160 of the judgment of Mr Justice Henry Carr. And the first 885 in paragraph 160, that's the prior art.
And the first passage of prior art that he refers to contains a list of some 13 different documents. And the first document is the document in which Wyeth and GSK were trying to find the protein. But all it is at this stage is just a reference to the document. So this is the equivalent at this stage to a marcouche or to saying, go and look at the books in the Bodleian. This is a generic disclosure and no more than that. And it's apparent from the paragraphs that follow that there are in fact tens of thousands of proteins encompassed by these 13 documents which are listed in the prior art. And you can see that from paragraph 161, the last sentence refers to, this is the third entry in the list. It's all even numbered amino acid sequences between 2 and 892, so that's some 450. In para 162, you get 2,000 amino acids, para 163 another 2,000 amino acids. So there are tens of thousands altogether in this list, so it is an absolute soup of potential proteins. Nevertheless, the judge goes on to deal with the fact that there is a separate disclosure in the 885 document of preferred proteins. And he goes on to deal with that at 164. And it's right that later on in the piece of prior art, there is a list, but that list just amounts to a list of sequence IDs, as paragraph 164 explains. So in fact, all that is a list of even numbers from 2 to 3020. So you still don't know what you're dealing with here. And the only way to work out what any single one of those even numbers refers to is to go to the previous document, which is called 280, and to look up the identity of the specific protein in that document. So you're sent on a chase to another document to do that. Moreover, even though it's right that one of the number of 1,500 proteins or the 1,500 sequence IDs in the prior art is listed, the prior art 885 then goes on to say these are our preferred proteins, and this is the judge at 165, and the protein that GSK had to point to was not one of the preferred proteins in the 885 prior art, nor was it one of the preferred proteins in the antecedent document, the 280 document, which you have to go to get the actual sequence, and that's what the judge found in paragraph 166. And the judge also notes that the experts, when they read these documents, they didn't notice it either. So it's completely unsurprising on the facts of that case that the judge found that it was not individualized, given the wild goose chase that you had to carry out to go to one document, go to another document, to choose one of 3 different lists and then ignore what the preferences were. So this is a different species of case to the case before you on this appeal. This is a hidden case or a perjuicy. And we say it's a million miles away from the present case where there is a single, very short list in 56. Even in example 31, there is a much, much shorter list than any of the lists in this case. We say it just can't assist you at all. So that's Wyeth. Then if we can turn to the judgment and my learned friend's submissions on the EPO case law and the judge's, the way the judge dealt with that. So this is the judge's paragraph 130. And this is where I pointed out yesterday that the judge was mixing the 2 types of cases, the Marcouche type cases and the list cases in this, and he shouldn't have been trying to draw the same parallels. And what my learned friend's explanation for paragraph 130 was yesterday, he said that the judge was just talking about numbers. But if that was the case, and all the judge was trying to do was to look at numbers, then he was clearly misdirecting himself. Because if you just look at numbers, then the number in the Herx case was just 2, because there were just 2 enantiomers. And if the judge was just focusing on numbers, because in the Herx case it was said not to be novelty destroying, that the description of the racemate for the enantiomers, that might have led the judge to think that a list of 2 concrete examples in some circumstances could be too long, because that was the outcome in the Herx case. But of course, in the Herx case, the real reason it wasn't novelty destroying was because the disclosure of the racemate did not disclose in technical terms the 2 enantiomers. They were not there in concrete language. It only did so intellectually. So my learned friend's submission only serves to highlight the risk that the judge went wrong later because he failed to distinguish between the 2 types of disclosure in the EPO. Indeed, as my learned friend this morning said, it's not simply a numbers game, but on his submission yesterday, it seems the judge was dealing with it as a numbers game, and that, of course, is wrong. Now, we observe that it might be said that the EPO approach to intellectual content is very strict, so that the notion that C1 to C4 alkyl doesn't disclose anything other than C1, the C1 molecule, and doesn't disclose any of the other 7 molecules, is quite strict. But what is absolutely clear is that the contrary cannot be argued. C1 alkyl definitely discloses the methyl. And that is absolutely clear throughout this EPO case law. And the distinction between intellectual content, or genus, of a marcouche, and the individualized description, that is to say the black and white concrete writing down of a molecule or a species, is now well settled in this jurisdiction as a consequence of Dr. Reddy's. And this is clearly a species case because the nucleotides are written down in black and white. And this strictness, the strictness of approach to the intellectual content might explain why the EPO don't seek to limit the length of a single list in their guidelines, because they accept that if it is there in black and white, it is there. And if it is there in black and white, we submit it's part of the state of the art, and so the later claim cannot be novel. And we're nowhere near the sort of complicated facts of something like Wyeth, where it's not just a single list, you're having to make different choices from different lists and different documents. And therefore, the only guidance we have, and no one has suggested that that is wrong, is Almirall, where a list of 159, they were all independently and individually disclosed. The next point on the law, my learned friend took you to paragraph 139 of the judgment, and he sought to characterise the observations of the judge as legal propositions in this paragraph. But at least the second point on combining lists is just a summary of some findings on a particular set of facts, not a proposition of law. And my learned friend's attempt to elevate the outcome of one individual case from this paragraph is wrong, particularly where nobody disagrees with the judge's summary in 136 that the law in relation to multiple lists and selections from multiple lists is not mechanistic and not formalistic. And therefore, my learned friend's attempt to rely on 139 is contrary to that. The penultimate point on the law, my learned friend this morning sought to suggest that wherever you have an alternative in a document, that's not novelty destroying. He did that by reference to the Synthon case, and he took you to the quote from Synthon on page 77 of the bundle, where the judge set that, Lord Justice Jacobs set that out in Dr. Reddy's. And so the extension of that point is, if you have 2 examples in a prior patent, neither is novelty destroying because neither of them are inevitable. In our submission, that's clearly wrong as a matter of law. It's dealt with, in fact, by the judge in Almeril at 212 to 214, where he explains that's never been the law. And indeed, Synthon doesn't support that either, because the passage that my learned friend took you to in Synthon, just under Dr. Reddy's after the quote from Synthon. It's where Lord Justice Jacobs says, where you have a patent for a particular chemical compound and a prior art general disclosure, performance of the general disclosure does not necessarily result. That is, he's there talking about a class, a marcouche. He's not talking about a list of specific molecules. And so Dr. Reddy's doesn't support my learned friend's submission. And indeed, if you go down to the quote from the Bundespatentgericht in paragraph 33 of Dr. Reddy's, you can see just the last full sentence in that quote, where they say, it is disclosed to him in a cited reference only where the prior art document contains a concrete indication of the claimed compound. And that's what we say, that's completely consistent with the EPO approach, which if you have something in black and white, that is good enough. Where you're not allowed to say something on this approach destroys novelty is where it's only encompassed by a generic marcouche, where there may be countless alternatives, but none of them are specified. So, my lords, we say all of this is of a piece and consistent with the law as I explained it to you yesterday. The final point on the law was my Lord Justice Snowden's question about the guidelines and the comment about reducing length. And what I anticipate that the guidelines are referring to there is the doctrine in the EPO that you are allowed to delete things from a list, and that's not said to add matter or confer novelty of the remaining items in the list. And there was an example of that in the bundles, and in fact the judge referred to it in paragraph 136, and it's case T783 of 09, and that's where they effectively said that it is not formalistic or mechanistic in the quote that the judge gives at 136. And I appreciate this is just the facts of that case, so let me tell you about them. I don't think we need to go to it. But in that case, it was permissible to reduce a list of 44 to 3, and by crossing out all the other 41, and that was not said to add matter or destroy or prevent a finding of novelty, and that was because in the right circumstances you can make deletions, and the only circumstances which the EPO suggests that you are not allowed to do that is where there is a specific different characteristic of the item you've left over. So you effectively, by crossing everything else out, you somehow make a new invention because you throw away all the things that don't work and you find the thing that does. And of course that doesn't arise in the present case because of the technical contribution that my learned friends relied on. They don't say that N1-methylpseudouridine is any different to any of the others. So that's why it doesn't arise here. But that is perhaps what the guidelines are referring to when they say you can't get it too short, because sometimes if you reduce a long list to 1 in the EPO, they say you've made a new invention, and effectively that's not allowed. That's not the case here because of there's no different characteristic that's relied on. So, my lords, that's the law. I was then going to deal with first of all Route 3 and my learned friends' submissions on that. One of the points that arose in relation to paragraph 56 of UPenn and the judge's observations was whether or not you were permitted, the skilled person would be permitted to find out if there were any other pseudouridines known in the art. And my learned friend had a discussion with my Lord Justice yesterday about whether or not that was CGK or obviousness. And we accept that you can't, if it's not disclosed in the paragraph, you can't go off and do a task that might be obvious to do, but for novelty you are stuck with what is in that paragraph. But equally, if you're stuck with the information given in paragraph 56, you also don't know that there are any other pseudouridines, so it's irrelevant to what is actually disclosed in paragraph 56. You have to have the same rule from both sides of the coin. There is one other point to make about this, my lord, which is that there was in fact some evidence about what the skilled person might expect looking at paragraph 56 before they had gone to look at the database. And I will just show you that if I may. So this is in the supplemental bundle at tab 16. And it's page 259 of the bundle, and it's page 186 of the transcript. And this is my learned friend asking Dr. Enright, and at line 5 he says, so before consulting the RNA modification database, they don't know how many or how large the number of psi-like modifications there are, correct? And then Dr. Enright gives an answer saying they wouldn't know the exact number, but he says the hunch would be somewhere between 3 and 7. So if you're allowed to take, if that, the judge didn't make any findings on this, but if to the extent that there was evidence before him, the common general knowledge would be, oh well, there's a handful of molecules. And so when you read paragraph 56 and you're given a list of 5, that is not inconsistent with the expectation that you would have. So it's not as if when you read paragraph 56 there was any basis for thinking, oh, I expect there to be another 20, which causes me uncertainty about what paragraph 56 tells me. So we say, actually there is no information in paragraph 56 either way, and that can't help my learned friend, but to the extent that there was any evidence, in fact, the list is consistent with the expectations of the skilled person from their common general knowledge. The other point my learned friend made a number of times about paragraph 56, he kept saying there's no technical teaching, but of course there doesn't need to be a technical teaching for novelty. In fact, you could have something that tells you about a molecule and then tells you that it doesn't work, but even if it said that, it still makes the molecule part of the state of the art. So, for novelty purposes at least. So we say my learned friend's submissions in that respect don't take him anywhere. The next point I was going to deal with was the new point, as I call it. This is the point that my learned friend made this morning. My main objection to this point is not that it's not in the respondent's notice. My main objection is that it was not run before the judge at all, as he now seeks to run it, and it wasn't supported by the evidence before the judge. And in fact, the evidence, it was either missing or it was sought to be used in a different way. And I want to make that point good by taking you to a couple of extracts. So can we first of all just remind ourselves what the point is? And this is in my learned friend's skeleton. I think he asked you to effectively include paragraphs 67 to 69 in his respondent's notice. That's what he's asking you to do. And the particular part which he now relies on is right at the bottom of page, so I'm in tab 21 of the core and Moderna skeleton, right at the bottom of page 322, where it said, notably, figure 10 also shows that the translation of mRNA containing M6A can be improved to the point that it is marginally better than unmodified RNA by reducing the percentage of M6A from 100 to 5. Thus, UPenn itself teaches no inherent correlation. It's not inevitable that 100% replacement will achieve both objectives. Well, of course, the first point we make is that the test is not whether it's inevitable or not. It's the same mistake the judge made when he said refer to something being necessary. The question is whether there are pointers to 100%, and so that last point falls away as a matter of law. But the evidence that he's seeking to rely on, the argument that he's seeking to rely on, is that you can improve the translation of M6A by reducing it from 100 to 5. That point was never made before the judge, has no basis in the evidence, and my learned friend shouldn't be permitted to take it, and it doesn't help him anyway for the reasons I'm going to come to. And the case as run before the judge was that M6A doesn't work at all. So it's absolutely right that if you have 100% of M6A, that abrogates all translation. And my learned friend sought to rely on that as part of the argument that small changes might make big differences. They sought to rely on the structure of M6A for that. But in fact, when, as you'll see, my learned friend put it to Dr. Enright, and can I take you please to, this is in the supplementary bundle at, yeah, sorry, we don't have this. Because I was only handed the documents by my learned friend this morning as your lordships came in, so I'm afraid I hadn't had time to prepare this. So there is a section of the cross-examination where my learned friend did ask Dr. Enright about our example 11. And what he said to Dr. Enright was, these data are consistent with M6A not being incorporated at all. In other words, the fact it doesn't work it means that when you try to transcribe the M6A nucleotide, it just doesn't get put into the RNA at all, and therefore you can't actually transcribe it. And there was a debate between my learned friend and Dr. Enright as to whether or not you can tell from whether you have 5%, when you've got, and this is the experiment where you have 95% of A and 5% M6A. And the question is whether you are getting some species which in fact have 100% A and they do transcribe, or whether or not you're getting some species with 5% M6A or 4% M6A and 96%, etc., that transcribed. And the doctor said he couldn't tell, which is absolutely fair enough. But what wasn't in dispute was that if you have 100% M6A, it just doesn't work at all. So it's not that 5% is better than 100%. The upshot is that 5%, having 5% of M6A in your mix doesn't kill it completely, whether or not it's incorporated, and we just don't know whether that's the case. And that, in fact, was the finding that the judge made in paragraph 406 of the judgment. I'll just show you that. This is a point about whether small changes make a difference in predictability, and he records in 406 at the bottom of the page 131 of the bundle, M6A, where a small change outside the interface led to the RNA being transcribed but not translated. So he's there accepting that it doesn't work. You can't get it to translate at all. So there's no basis to say that there's a teaching anywhere in the specification against 100%, either whether for immunogenicity or translation, once you take into account that, as the judge found and as was put to Dr. Enright, M6A is something that just doesn't work at all. And if your lordship just go to the report of Dr. Rosenecker, which my learned friend did take you to this morning, which is, this is tab 23 of the supplemental at page 323. And it's right that Dr. Rosenecker went through the examples, and you can see in paragraph 201, there's an M6A entry which has no translation, so that doesn't work at all. It's figure 9. And then in paragraph 202, Professor Rosenecker doesn't refer to that at all, so there's no reference to that. 203, you can see figure 10A, Ranilla M6A, no expression, so that again doesn't work at all. And then it's right that figure 10B, using a different cell type, there is some response for 5% M6A, whereas 100% M6A gets 0 response. And the observation that Professor Rosenecker makes in 204, he says, replacing all adenine residues with M6A abrogated expression, correct, and that's what the judge found in paragraph 406. And then over the page, he just makes the single observation, mRNA with only 5% of adenines replaced with M6A showed at best a slight increase in translation in murine DCs. And the reason he says that is if you go back to figure 10b, you can see that the unmodified is at the top and 5% is at the bottom. And actually, if you take into account the error bar, it's very difficult to say when you take into account the error bar of each of those columns whether or not 5% M6A is the same as none or any better, which is why the professor says it shows at best a slight increase in translation. But the professor never sought to rely on this as teaching that you would not want to have 100% replacement when you're making your mRNAs, because there's some sort of general teaching here that 100% replacement doesn't work for translation. The teaching here is that M6A is absolutely rubbish. It abrogates expression when you use it, so it's not something you're interested in using further. It's not about the percentages, and the professor didn't seek to draw anything from the percentages in this evidence. So, as my learned friend fairly accepted this morning, he's now trying to put the point to you in a different way to the way it was put before the judge. In any event, the judge has made...
He accepts it wasn't perhaps as clearly articulated, but his point was that the fundamental basis was, and it's paragraph 15 of the written submission as dated the 10th of May.
Yes.
Figure 10b shows that mRNA containing 5% M6A more efficiently translated than mRNA containing 100%. Now,
Yes.
you say that's wrong, but that's a different submission to saying it's not advanced the judge at all.
Yes, I don't say... The statement of fact, I obviously can't argue with the disclosure of the document, but what my learned friend didn't seek to do was seek to say that there was a generalised teaching here that the skilled person reading this document would understand from it, from this example, that they should not use 100% replacement. And the professor never suggested that. In fact, the professor suggested absolutely to the contrary when I put the various passages to him. I'm going to show you those in a moment. So what I don't escape from what that figure shows, my lord. But what I do object to is my learned friend attempting to use that argument, take it further and say, oh, there's some generalised teaching here. That's not a point made in that sentence. My learned friend accepts fairly that he didn't expand on.
His point is a negative one. He says, when you take this into account, you can't draw the conclusion that you should always use 100%.
Yes, but
he's using it as a shield against your argument, not as a sword of his own.
But we say that should have come out of either his expert's evidence or been put to my expert to say, well, even though there are teachings in the document to use 100%, which my learned friend accepted yesterday, that he needed to extract evidence that this exception, which he now seeks to rely on, undermines the generalised teaching of the document. He never sought to do that. And he didn't seek to do it with the judge in oral closing either, even though he's now found that sentence in his closing and seeks to rely on it. So, if I can try and draw this together, my lords, even if you're to take any of this into account, we say all the evidence before the judge was that the pointer was to 100%, and 100% being better. And my learned friend made two important concessions yesterday afternoon just before the close. Firstly, he accepted that claim 1 of UPenn would be understood to be claiming mRNA containing the N1 methyl substitution. That's page 153 of the transcript. Next, he conceded that there was expressed disclosure in example 7 that 100% modification is the best for reducing immunogenicity. That's at 156 of the transcript, where he accepted that that statement is taught in paragraph 213 of UPenn. Now, what he went on to say was that there was no clear message from the end of example 7 that 100% is better. And of course, you have my submissions on that. We rely on the title of example 7. We rely on paragraph 213, which my learned friend accepts, does it teach it? And we also rely on the last sentence of example 7, which also gives you the general principle. But there was also some evidence on this coming from my learned friend's expert. And if I can just show you that very briefly, it's in the supplemental bundle, tab 18. And it's page 516 of the transcript, so it's bundle page 287. And I pick it up first of all at line 5, and I asked the professor to read paragraph 208, and this is in fact another pointer in the document which I should have showed you yesterday, but before example 7 starts, there's a statement in paragraph 208 of UPenn saying an increasing amount of modification decreases the immunogenicity of RNA. And I put that to the professor, and he read it, yes, he reads it out, and he says, yes, so again the skilled reader is given a reason to want to use 100% modified nucleotides, correct? Yes. Then I go on to put example 7 to him, and I put to him, I say, although they are deliberately varying the percentages, and the results they get is that they find even small amounts of modification do have an effect, the overall trend, as we have seen, was that the reduction in immunogenicity was proportional to the percentage of modification. Yes, I agree. That is another reason to want to make 100% modified nucleotides. Correct. And there's no suggestion from the professor that somehow example 11 takes away this reason to make 100%. No, it wasn't put to the professor in re-examination. Example 11 somehow takes away from this, nor was it put to Dr. M. So we say the message is clear. You have the general teaching some 5 times in the specification. Paragraph 143, paragraph 186, 208, 213, 218. You have the statement in 143 which says, as provided herein. So that invites cross-references to the examples. And 143 also expressly covers both translation and immunogenicity. So it teaches the principle for mRNAs. And again, if my learned friend had wanted to try and undermine what was said in 143, that would have needed to come from evidence, and it didn't. And further, it makes no sense to make separate molecules for testing immunogenicity and translation. Example 2 is used for all of the following examples, both the immunogenicity and the translation examples. So the skilled person would make 100% modified mRNA to test both immunogenicity and translation. And so when read as a whole, we say there are multiple pointers in the document. And this is both consistent with the CGK through which the reader reads the document. And the pointers are strong, and there is no basis for my learned friend now to seek to undermine it with a new point, which just wasn't explored with the experts at trial. My lord, the final point on novelty was my learned friend trailed at least twice yesterday that he was going to come on and deal with paragraph 337 of the judgment. And in fact, he never did so. And we say he just is unable to defend the points, the criticisms that we make of the judgment in that paragraph, the suggestion that a lesser percentage might be just as good, the suggestion that something needs to be necessary to be a pointer. And we say, my learned friend's failure to deal with this just undermines the weakness of the case, which he is now seeking to make to defend the judgment. We say, for all those reasons, we should prevail on route 3. My Lord, in the last couple of minutes, route 1, my Lord, my learned friend took you to paragraph 324, and he suggested in 324 that what the judge was explaining there was not when he used the word may in relation to example 2. All he was saying was that you don't have to go back and make the 5 mRNAs, and that's what the judge meant. And we of course accept that and endorse that. We say it tells you to use the method of example 2, and you don't have to go back and make the specific ones, but what you do have to do is make an mRNA, because you have to test it for translation. And that, of course, is good enough for us, because that gets you to the claim, and it also gets to 100% because you have to follow example 2. And so when my learned friend then tried to go on and say, rely on 326 and 327 and say, okay, these weren't just about poly A tails, it's all about the specific proteins in example 2. He was contradicting himself, because he says, and we accept, that you don't have to make every single molecule in example 2 to follow it, but you do have to make an mRNA, and the fact that there's no instructions to which specific mRNA you have to make doesn't matter, because all mRNAs, or anything you do to test for translation, has to be an mRNA. And so the general instruction is enough, because it makes it truly inevitable within the sense of the novelty test that you will arrive within the claim. You have to test for translation, it has to be an mRNA, you follow example 2 as my learned friend accepts, and you end up with 100%. So for all those reasons, we say we're right on route 1 as well. And the final point is, it just in 328, my learned friend, where the judge says the mRNAs would be especially useful for some of the purposes. Of course, that's not right, because it's necessary. It's not just useful. You have to test an mRNA if you want to test for translation, and so that's another place where the judge got it wrong and misinterpreted the teaching of example 31. Well, Lords, I've realised the time, and it may be that I haven't got time to deal with the points on obviousness, which I've already made them, I think.
If you just want to do that briefly.
I'm very grateful. I will take 2 minutes. The point that really comes from paragraph 261 of the judgment, where the judge correctly finds that all of the teams above were looking for practical results. And the problem with the judgment is that that team includes Dr. Enright, because Dr. Enright was part of 4 above. So once we have that problem, we then have the observation in 266 that the identity of the skilled person is crucial for obviousness. So once the judge has made the mistake of excluding someone like Dr. Enright, who was looking for a practical result for obviousness, then everything else falls away, including the expectation of success, because Dr. Enright set out the reasons why his skilled person would want to take EUPEN forward, and he didn't need an expectation of success per se, but the judge just didn't consider that skilled person for obviousness. The hindsight point doesn't help, because my learned friend mentioned the Brand point on hindsight, but the Brand point on hindsight only went to Charette and Gray, which we accept. And so when he goes on in the end of his submissions to say, oh, well, if you had patients, you'd only want to try pseudouridine, that was accepted, and that was the position of Professor Rosenecker. But if you're not in the clinic with patients next door suffering from cystic fibrosis, but instead using reporter proteins in the way that Dr. Enright was in little 4 of the judge's list, then there's nothing to undermine the written evidence he he gave, and my learned friend didn't show you anything to undermine that, to take away from the fact that it would still have been routine and obvious to test the molecules in paragraph 56. Final point, my learned friend sought to rely on the animal experiments, but of course you only get to the animal experiments once you've done the first set of experiments to make the nucleotides, and making the nucleotides is all you need to do, or making the RNA with the nucleotides is all you need to do. So there's nothing in our submission to assist my learned friend in anything else that you said this morning on the obviousness appeal. Unless I can sit you any further, I apologise for trespassing.
Not at all. Thank you very much. Thank you for your comprehensive submissions, and thank you to everybody in your respective teams who've been involved in the construction. We are going to reserve our judgments. They will be provided to you in draft with the usual limitations to correct the grammar and not to be distributed or used for other purposes. Do you want the transcripts?
We've already had yesterday.
Have we? Okay. You'll provide us with the transcripts. And we would hope that once you receive the draft judgments, you'll be able to agree the order, but if not, we'll deal with any outstanding matters on paper. So thank you very much.
All right.